an attorney in Pueblo, and I do a lot of real estate stuff, and I do some estate planning stuff. And this morning I'm going to teach you a class about evictions, working through the maze. I've been doing evictions for 20 some odd years, both on the landlord and the tenant side, mostly on the landlord side, but there is representation for both available. And I'm going to go through what's currently the law in Colorado. And when you look at this, you may want to take a look at what the current law is, because with COVID impacting a lot of what we're doing in evictions, it may change by the time you look at this. And I'm going to cover some of that in detail as we go through all of this. This right here is all of my contact information, my phone number, my email, the website, Facebook and Twitter, and my YouTube sites. And of course, if you want the presentation, just send me an email, say, hey, can I get the evictions presentation? I'd be happy to email it to anybody who wants it. Okay, so evictions, they all start with a lease. The lease may start off looking something like this. Most leases are written, and they should be written. If any landlords are watching this, I deal with a couple of landlords, both of whom are in their 80s, who still believe in doing business on a handshake. That's a lousy way for both sides to do business. Anybody should insist on having a written lease, because that way you won't have any contradiction as to what the terms are of the lease if you get into court, if you have a dispute. For instance, the landlord may say, well, your rent's $1,000 a month, and the tenant says, well, my rent's really only $500 a month. And if you have an oral lease, who is the judge going to believe? Well, if your lease is written, it's very clear as to what the amount of the rent is and what the provisions are in the lease. And so it's very important for both sides to have a written lease when you go through and sign up for a place. When you have a lease, and the evictions are going to start when somebody violates it, or the landlord alleges that somebody has violated it. And when that happens, the landlord is going to serve one of these two forms. And I'm going to show both of them in just a second, but this is just a summary slide. The demand for compliance or right to possession notice is otherwise known as a 10-day notice. And the second one is called a notice to quit. The landlord can serve those forms by themselves. They don't need a professional process server. They don't need a neighbor. They're not conflicted from serving this form themselves. The landlord can go right up and post it on your door. It needs to be posted in a conspicuous place. That means it has to be visible, and it has to be obvious to whoever's living inside that house or apartment that there is a lease violation that the landlord is alleging. And so these forms are then served. One of these two forms are then served. Okay? The landlord is going to be using a demand for compliance form if they want the tenant to comply. For instance, the landlord is saying you haven't paid your rent, or they're saying you have unauthorized occupants, or you have unauthorized pets. And so the landlord wants to give you a little bit of time to comply and have you stay there. They give you a notice to quit, which is that second form, when they just want the tenants out. They're tired of dealing with them, and all they want is what's called possession, or getting the property back. They're not looking for money in that case. They are just looking to have the tenant leave. Okay, if you leave after that time, there's nothing that goes to court. And this is an example of the demand for compliance or right to possession notice. You notice right here that there are different dates that are required. And let's go through those for a second here. This is a standard state form. It's not officially required, but it's the best one to kind of use because it has different check boxes that the landlord can check. So if it's a residential agreement, the landlord has to give you 10 days to comply. That is the 10 days from the date right down here at the bottom of the form, which is called the return of service. They have to give you full 10 days to comply with that. Under normal market conditions, that also includes the non-payment of rent. So if the landlord is saying that you haven't paid your rent, which is the case in over 90% of the cases, then that's the checkbox they're going to use. The legislature a couple of years ago enacted a new law, and before the new law was enacted, the landlord only had to give you 3 days notice before they could file an eviction. Now it's 10, but they gave an exemption for property where it's called an exempt residential agreement, where the landlord has 5 or less properties, and the landlord has a lease which specifically says they can start the eviction process on a 5-day notice. So when that happens, they can fill out this second box right here. Employer-provided housing agreement, that's 3 days. That's rare that we have one of those cases. I think I've only had one in all these years I've been doing this. For a non-residential agreement, that means a commercial property, like an office building or a warehouse, something like that. For commercial agreements, the landlord only needs to give 3 days notice before they can be given eviction. Substantial violations is also 3 days. A substantial violation basically means a crime. Tenants are running drugs in there, or they're running prostitution, or they're doing something else that's really substantial in there. If it's enough to involve the police, usually that qualifies as a substantial violation. And the landlord can give somebody the notice to comply within 3 days. Okay, so this is where the address is stated on the property. The landlord should, but they're not really required to, put the legal address of the property on there too, but most do. I haven't seen one kickback because the legal address isn't specified. But if you had two similar addressed properties, then you would need the legal description in that case. All right, so this is where the landlord would check off what they're alleging you haven't done or have done that was in violation of the lease. This top box is by far the majority of what problem cases are. They're saying you haven't paid your rent, and they have to specify the amount that's owed right here, as well as the dates where it's owed right down here. If there are other lease violations where they want you to comply, they put them right down here. So that's if you have unauthorized occupants, or you've snuck in a pet, or you've done a number of other things. You're smoking in the place when smoking is not allowed. This is where they put those other violations on the form, and they then give you 10 days to comply. The landlord signs right here, and of course the landlord states right up here what the rent is per month, and they date it. They sign right here, and if the landlord has an agent or an attorney to serve it for them, then that person signs that right there. This return of service you see here at the bottom does not have to be filled out when the paper is served on the tenant. In fact, it won't be filled out because the landlord hasn't actually served the document. But what they do is after they serve this form on the tenant, they have to fill out this bottom portion of it, and that's what we use if we go to court. And again, this has to be posted in a conspicuous place that is an obvious place for the tenant to see, and it has to be filled out completely. And then at the end of at the end of the waiting period is when the landlord can begin eviction. Okay, with a notice to quit, this is a standard notice to quit form. Again, this is where the landlord is just trying to get you out, and they're not looking for any money. Okay, so whoops, hang on a sec here. I leap forward. There. Okay. All right. So on the notice to quit, this is a standard notice to quit, and right down here it specifies the time period where the landlord has to give you to vacate, to leave the property. Again, this is where they're just looking to have you leave. They're not looking for any money damages. They're not looking for other damages for unpaid rent or for having people that are in there that are not allowed to be in there or smoking, etc. They're not allowed to they're not using this form for that. They are just using this form to get possession of the property back. And this is where they specify the name of the tenant. And then if they're looking to evict any and all occupants, they put that right there. And here's where they specify the date you're supposed to be out. And that date is determined right by the statute, which is right at the bottom of this form. So how long do you have to go on your tenancy? So if you're in the middle of a year-long lease, the landlord would have to give you a 91-day notice to leave here. That's a long time. If you're on a 6-month lease, but less than a year, that's 28 days. If you're on a month-long lease, but less than 6 months, 21 days. And let's stop and cover this one real fast because this is by far the majority of the cases I get. What happens is you have a lease that's gone on for a year and now it's expired, and now it has converted to a month-to-month lease. And once it converts to a month-to-month lease, then the notice requirement is 21 days before they can begin eviction on you. If your tenancy is 1 week or longer, but less than 1 month, you see this in some makeshift old motels, which have been converted into residential housing. Oftentimes you'll see those there. And the notice period is only 3 days there. If there's a tenancy of less than a week, it's 1 day. So if somebody that is in a hotel, for instance, and the landlord needs to bring an eviction against them, they only need a 1 day notice before they can file eviction. So these are just other requirements of the notice to quit. but it's very similar to the demand notice in this respect, and that is the landlord fills in these boxes, they fill out the street address, the legal description, they specify the tenant's names, and then they date it and they sign it up here. And if they have an attorney or property manager, that attorney or property manager is going to sign in that second one. And then after they've signed this original form, they fill out the certificate of service at the bottom, this one, and this is what a landlord is going to have to supply their attorney when they start an eviction process. They need to have the completed form as well as a copy of the lease. And that's what an attorney is going to use to start the eviction in this case. All right, this other one is a notice to quit for substantial violation. Substantial violation does not mean non-payment of rent. It doesn't mean unauthorized occupants. What it means is basically you've committed a crime. So if you're dealing drugs in there, then that's a crime. If you are beating up the walls and terrorizing the neighbors, that's a crime. Anything that's worthy of calling a police action in is a substantial violation and can be a grounds for throwing you out. So they specify the name of the tenant right here and any and all other occupants. They tell you what day that your tenancy is terminated and the time, and they specify the street address, and then they also specify the legal address of the property. And this is where the landlord has to say why they are evicting you under a substantial violation. All right, so, and they have plenty of lines to do that there, and the state makes you fill in whether you're filling in the blanks yourself or you're changing things around. The landlord dates it and signs it right there, or their agent does right down here. And then after it's served, they complete the certificate of service, they get that to the attorney, and the attorney files the eviction from there. All right, whichever form is used, the landlord is going to post one copy on the front door, or they'll hand it to the tenant. Whoops. Yeah, they're going to post one copy in the front door and they're going to hand it to, or they'll hand it to the tenant. They don't need personal service when they do this form. So all they're doing is starting the clock by posting this form. This is the very beginning of the eviction process. In the case of a demand notice, they're just looking for you to comply. And if you comply, then you can stay there. If you don't comply, then they're going to try to evict you. The notice to quit, again, they're just simply saying, we want you out. And there's no excuse. We just don't want you living in our place anymore. So after the landlord posts or their agent posts the notice, then they wait out the required period. So if you have a month-to-month lease, which is what the vast majority of them are, then the landlord's going to wait 21 days, and they're going to wait 10 days if the landlord alleges non-payment of rent. And again, I'm going to cover this in more detail when COVID is concerned on the next series of slides. And then 3 days if it's for a substantial violation. So that eviction notice is not the actual court filing yet. That comes next if you don't comply or you don't leave. Now, COVID has changed everything. First, in March, at the beginning of the COVID crisis, Governor Polis came along and started instituting a bunch of orders regarding evictions, and especially when it came to non-payment of rent. He alleges that non-payment of rent may be due to somebody losing their job due to COVID, and that sure has happened. That people have lost their jobs due to COVID. His orders really were quite substantial for most months, but the most substantial ones ended at the end of December. And currently, at the time I do this, the only order that Governor Polis has in place respecting evictions is that landlords cannot demand a late fee for January. Again, you'll want to check this at the time you view this, because Governor Polis has been issuing executive orders ever since this whole thing started back in March. And every 30 days or less than 30 days, he issues a new executive order. But the only one he has in effect right now is that landlords cannot collect any late fees. Okay, as far as Governor Polis is concerned, his actions do not impact any other reason for evicting somebody. So if you have evictions based on notices to quit or substantial violations or unauthorized occupants, then the evictions can still proceed. So that's what Governor Polis has been doing. This is the other one that's been making more news than even what Governor Polis has been specifying, and that is back in September, the Centers for Disease Control instituted a big blockage for evictions that were based on non-payment of rent. What happens is if a tenant fills out a form a particular form, then in most cases, the evictions are going to stop if the evictions are for non-payment of rent. So as you see in that second bullet point down here, you may avoid eviction for non-payment of rent if you fill out an affidavit which states 4 things on it. You have used the best efforts to obtain government aid for rent or housing, and there is government aid available. If you do a Google search on government aid for rent payments, so if you're behind on your rent and you're looking for a way to pay it, you don't have a job, times are tough, then you can do a Google search for government funds to pay for rent. You can also go visit several charities around town. I think the best charity around town is Catholic Charities. They have given out a number of rent payments and security deposit payments for people, but other charities have done the same thing. Blue Star has done them. Salvation Army, I remember getting one payment of rent from Salvation Army for somebody who was hard on their luck. So charities do it too, but there is government assistance that's available for people who are unable to pay their rent. The second requirement is that you've not earned any more than $99,000 as a single person, or if you're married, filing a joint tax return, $198,000 on an annual basis. You're unable to pay the rent due to a loss of job, income, or medical expense, and you're using best efforts to make timely partial payments. So let's talk about that last one for just a second. If you are just using this as an excuse to not pay your rents, it's not going to fly, because you have to do something. You have to make partial payments. You have to make some effort to take care of your rent payment. COVID does not give you, as a tenant, a free ride. You still have to make your rent payments, and there's no excuse to not pay your rent. So what can happen in counties like Pueblo right now is that the landlord, if you're not paying your rent, they may not succeed in evicting you from the place, but they can still get a judgment against you for you're not paying your rent. So it still is a very serious thing. You can still have a judgment on your record, even if they're having difficulty evicting you for a non-payment of rent. The landlord oftentimes will bring an action in small claims case against you to try and collect that rent. And once they get that judgment, they're going to go to garnishment or turn it over to a collection company to try and get the money out of you. So this is not a free ride. And the affidavit actually has to be true. So if you are using these as lies and you really haven't lost your job or you haven't lost your source of income, you could be prosecuted for filling out a false affidavit. Okay, so and again, that form that was issued by the Centers for Disease Control, the CDC, they only apply where the landlord is trying to evict you based on non-payment of rent. So another reason to keep an eye on this thing is that the exemption is scheduled to end on January 31st. If you're looking at this after January 31st, you'll want to check what's currently in effect. And you want to check with both what Governor Polis has done, as well as what Congress has done, or the CDC has done, because either the Congress or CDC could expand the moratorium on evictions for a longer period beyond January 31st. And my guess is that they will take some sort of an action, because the pandemic is still with us at the time I'm making this recording. And when the landlord prepares the eviction, in both counties, these are the documents that they serve: the summons, a complaint, and an answer form. These are actual court documents. Now, a lot of tenants complain, okay, when I got these forms posted on my door and mailed to me, they weren't personally served. They don't have to be personally served. If they are either personally delivered to you or they're delivered to a family member over 18, that also works. If they're not able to serve anybody, then the process server will put the papers on the door and they'll also mail them to you. But these are the basic forms that are required. At the time you get them, sometimes there will be a case number on there and sometimes they won't. If an attorney is filing the case, the attorney will have you served first, and then they'll file the case. Whereas if a landlord is doing everything themselves, they'll file the case and get a case number and then have you served. So it could be either way. Sometimes you'll have a case number, sometimes you won't. Okay, in El Paso County, the landlords also serve a consent to assignment to magistrate. I think most of you are in Pueblo County, so most residents in El Paso County aren't going to be that concerned about this. But in El Paso County, evictions are currently stopped until February 5th, and that's because of the COVID crisis. Most court cases in El Paso County have stopped entirely until then. Pueblo, they're still open, and it doesn't look like there's any sign of the courts closing anytime soon. But again, El Paso County is closed, but not Pueblo County. Okay, for the time requirement for service, the tenant has to be served no less than 7 days, nor more than 14 days before the hearing. So that gives you plenty of time to prepare. And the initial hearing in Pueblo County is what's called a return of service. If you have one adult on the lease, then that adult has to be served. If you have more than one adult on the lease, then each of them has to be served. And also, the landlord will have served any and all occupants too, just to make sure they don't have somebody else that snuck into the place and that they have to get rid of them extra. They want to take care of everybody all at once. Okay, a person can be served for their spouse or family member, and the process server knows how to do the rules. And this is the area when they're serving the actual court papers. This is where a landlord is going to want to get a professional process server involved, because they know who needs personal service and who doesn't. Okay, if landlord hires an attorney, that's what the standard practice is. There are very few attorneys that represent tenants. They exist, but there are very few of them. It's tough for a tenant, because if you're being accused of not paying your rent, how are you going to all of a sudden cough up enough money to go hire an attorney? That's kind of difficult to do. Some people have done it, but normally that's very tough to do. Most attorneys just represent landlords because of this. Because again, if the landlord is trying to evict a tenant for non-payment of rent, the tenant is not likely to have money to come in and go talk with an attorney. And for other firms, it's just standard practice that they only represent landlords and not tenants. Okay, so if you were a tenant and you're facing eviction, one of your first calls should be to Colorado Legal Services. This is a free service that represents tenants, and you can give them a call and see if you can be on their list. Now, if you're somebody who is just trying to skimp the system and not pay your rent when you owe it, they're probably not going to represent you. But if you have a bad landlord, for instance, one that's not taking care of the place, or is taken off your front door or something, then yeah, they're probably going to represent you. But a lot of the times they're just backed up. I just know during the holidays, Colorado's Legal Services wasn't even taking any new cases. They were so bogged down with work. But again, if you're able to get them, it's great, because it is a free service to tenants. But you better have a really good case if they're going to get involved for you. Okay, let's talk about habitability. Habitability means that the place is ready to occupy, that it's something that's livable. Habitability really means livable. And there are certain standards that landlords have to follow when they provide housing to you. Number one, waterproofing and weather protection. So if you have a big gaping hole in the roof, that doesn't fly. They got to fix it. Okay, plumbing and gas have to work. There has to be running water and reasonable amounts of hot water. The reasonable amounts of hot water, that oftentimes becomes a problem in larger apartment complexes where you have one or two people who are hogging all the hot water, and that means there's nothing left for anybody else. So that's a common problem in large apartment complexes. Heating facilities. Heating means heating only. You realize that in Colorado, air conditioning is not a condition of habitability. So picture now you're in the middle of July and you have a big heat wave running through, and Pueblo's up at 100 degrees. Okay, the landlord is not required to supply you with air conditioning if they don't want to. They're most likely going to want to supply you with air conditioning, but the law does not require air conditioning. I assume that's going to change in the future, because Pueblo is a really hot area, and it's just a matter of time until it's required, but it's not now. Okay, so the landlord's required to clean the common areas, keep it free of bugs. Now, if you bring the bugs in yourself, you're responsible for them. And many landlords, if you occupy a single family home, the landlords will require you to take care of the bug problem yourself, because if a bug problem came in, it's because you brought it in. Whereas if it's in an apartment complex, it's difficult to determine who brought the bugs in, and landlords typically don't charge for bug service. Okay, part two of this, the landlord has to take care of the appropriate extermination of pests. Again, if the tenant brings in the bugs, the landlord's not going to have to be responsible for getting rid of them. It's just the tenant who has to get rid of them in that case. You have to have enough garbage cans. The floors, stairs, and railings have to be maintained. So if the railing's falling apart or the stairs are falling through, that's something the landlord has to fix for you. You have to have working locks on doors and windows. There has to be compliance with local building codes. Let's talk about that one for just a second. Sometimes violation of building codes is caused by tenants. And oftentimes tenants leave garbage outside, or they have an untagged vehicle, and code enforcement comes around and checks all these places. And when code enforcement comes and checks, and they see a violation, they're going to send a violation notice to both the tenant as well as the owner of the building. And if you violate local building codes, it's probably also a violation of your lease. And that gives the landlord an excuse to file eviction against you if you don't comply. So if you keep your place like a pigsty, not only are you going to get a fine and hauled into court by the local building code authorities, but you're also going to face eviction because the landlord can't come around and clean up all your mess for you. You have to, when you are a tenant in a place, you are a grown-up, and you have to behave like a grown-up, and that's taking responsibility for what's on the property. Okay, mold. Mold really was not a big issue until I would say about 10 years ago, and all of a sudden it's become a bigger issue. Pueblo and Springs, they're very dry areas normally, and you normally don't have much in the way of mold, but it has happened. And if it's tenant caused, the tenant has to fix it. But if this is something that's slowly been happening over time, then the landlord has to fix it. You have to have functioning appliances. So what good does the stove and oven do if they're not working? They have to be in working condition. And the roof, windows, and doors have to all be in working condition. And everybody just says, this looks, well, duh. Why do you have to specify that? Because sometimes people don't comply with that. And there's a lot of times landlords want to skimp out on this when good tenants are paying their rent and the landlord's not taking care of this stuff. The tenant now has a defense if the landlord tries to evict them, because you've been a good tenant, you've been paying your landlord, yet the landlord hasn't been keeping the place up. So let's talk about what some of the remedies are if you're in that situation where your landlord is terrible, but you're a good tenant taking care of the place and paying your rent on time. If you've got one of those habitability issues that I just covered right here, then you have to give a written notice to the landlord specifying the problem and giving the landlord no less than 10 days or more than 30 days after the violation. And texting is now okay. It used to be when you had a lease violation, or not a lease violation, when you had a problem with the habitability of the place, that the tenant had to write a letter and send it out, snail mail to the landlord. That was fixed a couple years ago, and texting is now okay. But now you want to keep a copy of that text in case you have a dispute with that landlord. And the text has to specify what the problem is, and you have to give the landlord sufficient time to take care of it. And you have to give the landlord 5 business days from the date of receipt to remedy that breach. In other words, to fix whatever the problem is. If the stove is out, you have to give them at least 5 business days to take care of it. And in some cases, you need to give them longer. Sometimes contractors get bogged down. Sometimes the landlord is out of town and can't be reached. So sometimes you have to give them longer. But this is the absolute bare minimum of what you have to give them as far as the time requirements go. All right, so if the landlord doesn't leave your basic requirement, if the landlord doesn't comply, if they don't fix it, the basic remedy is to leave. However, this does not give you an excuse to get out of paying rent. People have this big misconception that if the stove isn't working, you don't have to pay your rent. Not true. You still have to pay your rent. This does not give you an excuse. Okay, what it does give you is a defense in case the landlord sues you for eviction. So if the landlord sues you and the stove isn't working or there are leaks all over the place and you have one of those violations, you can claim the place is not habitable in defense. But even then, you still have to be ready to pay all or part of the rent into the court registry. The court registry is the treasurer basically down at the county courthouse. And when a judge requires that a tenant pay some money into that court, that's where you pay it. And at the time you file your answer is when the judge will require you to pay whatever monies that the judge requires you into the court registry. So you pay your money and you file that answer on that very same day. And when you do that, then the money will be held in the court registry until it goes to trial and the judge determines who is entitled to it. If the judge determines that the landlord is entitled to the money, they may still keep the money in the registry until the trial on damages take place. Now, Pueblo and El Paso County are very similar in a couple of respects, and that is if there's a trial, the first determination is who is entitled to possession of the property. That is, does the landlord get the property back, or does the tenant remain in possession of it? If the tenant remains in possession of it, most likely the judge will refund the money that's in the court registry back to the tenant. But if the tenant loses and they schedule a trial on damages, it'll be held in the court registry until that trial on damages takes place. But you also have to have an answer on that return date. The return date is the first hearing you have in front of a judge. And it's a little bit different between El Paso and Pueblo counties. But again, El Paso County is closed. But in Pueblo County, you have to file your answer and any defenses on the day of the return of service. So that's the initial court date. When you're given a court date, that's your initial court date. It's also called the return of service. That is not your trial date. Okay? Pueblo and El Paso counties both split them up. In other words, that is the date where a trial is going to be scheduled. But before a trial is scheduled, the judge is going to make a determination as to whether or not you have a good defense to whatever case you have. If your defense is you're going to be homeless afterwards, and that's your only excuse, or you don't have the money because you were laid off, those aren't good excuses, and you're probably going to lose. If you have a valid defense, then the judge will require you to file an answer, and then they'll schedule a trial date. And so that's what will happen on that return date. But you do have to go to the court date, and you have to go personally unless you hire an attorney to go for you. So again, on that return of service date, either the parties show up or they have attorneys who show up for them on that return date. And then when the trial is scheduled, all parties have to show up then. Now with COVID, what a lot of courts are doing, including the one in Pueblo County, they're allowing people to appear by WebEx or sometimes even by telephone because they want to have as few people going down to the courthouse as possible. And this is really convenient. People can sit at home on their laptops or even on your phone screen. You can appear that way if the judge gives you permission to appear that way. Okay, so there are some circumstances where you can provide written notice of a defect and then wait out the required period and then fix the defect and deduct the cost of the repairs from the rent. But you have to give proper notice first. Remember what I said back here. You have to give the landlord written notice. And again, texting is okay. You have to give the landlord written notice. You have to give them a chance to fix it themselves. And if they don't, that's when you have certain circumstances where you can fix the problem yourself, save your receipt, and deduct the amount of that fixing from the rent. Again, this does not excuse you from paying rent. You still have to pay the rent. Okay? It still is a fairly new area. This was enacted in 2019. But the bottom line is none of this gives you an excuse to not pay rent. Even if you lost your job due to COVID, you still don't have an excuse to not pay your rent. Again, the landlord can still bring an action in small claims court or other county court action against you for the non-payment of rent, and you may get a judgment against you as a result. Sometimes they're able to combine the two. So they go to the eviction court, they try and get a judgment for the possession of the property against you, as well as a money damages claim against you. Sometimes they go together, sometimes they're split. But the bottom line is you still owe rent. Okay, El Paso County now varies as far as the return date. That's your initial hearing in front of a judge or a magistrate. In Pueblo County, those days are Mondays and Thursdays at 8:30. As of the time I make this recording, the Pueblo County Courthouse is still open and people can still go there in person. But there is also a possibility of filing by WebEx or of appearing by WebEx or by telephone. But you have to seek the judge's permission in order to do that. Normally, if you are a tenant who's being sued for eviction, you want to go to the return of service at first date, and then you can ask the judge whether you can appear by WebEx or by telephone on the actual trial date. Okay, so if you have the return of service, then if only one side shows up, that side typically wins. And that assumes that the landlord's paperwork is in order. And if you're the tenant, you have to file an answer by that first hearing date. You can also, if the landlord is claiming non-payment of rent, there's a certain affidavit, that's a form you can fill out, claiming those 4 conditions I mentioned earlier about what the problems were with paying the rent, which was right back, let me find it, here. Okay, there's a form you can fill out that specifies these requirements on there that you fill out and you sign and you bring to the hearing with you. You have to file that form on the date of the hearing, and if you don't, then you're going to lose. You have to file your answer on the date of the hearing, or you're going to lose then too. So there's a lot of things to consider here. So these are your current hearing days, and you have to file an answer again by that hearing date. If both sides come, the clerk will schedule a trial in front of the magistrate to determine possession issues. The difference here between El Paso County and Pueblo County is that your hearing in El Paso County is done in front of the magistrate. In Pueblo County, it's done in front of a judge. As far as you're concerned as a tenant, there's really no difference between them. The differences between the two are very, very technical. So in both cases, the damages issue, damages does not mean just physical damages. It also means unpaid rent. So don't be confused by this word. Damages means not only you ruining the carpet, that's physical damages to the property, but also what have you not paid in rent? And the judge will make a determination on that on a trial on damages. So there's really three events that are involved here. First is the return of service date, and that's the day where a tenant is supposed to file their answer. The second one is on the trial for possession of the property. That is, does the tenant have to give up possession, or does the tenant get to stay there? And the third one is a damages trial. So that is where a landlord's seeking damages from the tenant, and the tenant can make any counterclaims for damages from the landlord. So if you go to trial in Pueblo County, attorneys have a luxury of filing this stuff online, and it's pretty nice because there are monitors all around the courtroom. So whatever attorneys present, you're able to see right over the computer. And others can bring in a flash drive and show them there too, under normal circumstances. During COVID, that may be cut off a little bit. But if you go to trial, you want to bring any witnesses that you have. You want to bring 3 copies of all documents you plan to use. That's exhibits. One is for the judge, one is for the other side, and then one is for you to reference, or your witnesses to reference when they're testifying. And you can't use anything from your phone. So I've seen this countless times when I'm in court and tenants try to bring up something on their phone and show it to the judge. That doesn't count, not unless you want to have your phone go into evidence and you lose your phone. So print everything and bring it all to court with you. And again, 3 copies, one for you, one for the other side, one for the judge. Okay. When possession is awarded, that is the judgment. The judge says there's a judgment for possession in favor of the landlord. Then the judge gives officially 48 hours. That's what the book says, but in reality, it's 2 business days to leave. So let's just take an example. If the judge gives possession on a Thursday, you wait until 2 business days are gone before it becomes effective. It's on the Thursday, so Friday is a business day, and then Monday is a business day. That is when the judgment for possession becomes effective, assuming Monday is not a holiday. So a judgment given on Thursday will become effective on Monday. A judgment on Monday is typically going to be effective on Wednesday. It's 2 business days from whenever that's effective. So what happens at the end of those 2 business days? The landlord files a document called a writ of restitution with the court. That's fancy language saying there's an order for the county sheriff to throw the tenant out if they've not left already. That's what the writ of restitution does. And the writ of restitution is a document that the sheriff gets the judge to sign, and not the sheriff, the landlord gets the judge to sign, and then they take it to the sheriff to have the tenants thrown out. So these are the locations of where the landlords are going to take all this stuff. In both cases, they're pretty much the entrance to the local jails. And they'll tell you right here what the filing fees are and all this. And this is only going to interest landlords. It won't interest tenants. But it's based on the mileage. And that's what the county sheriff charges. On the moving day, the sheriff's department will before the moving day, the sheriff's department is first going to take a trip by the property, and they're going to post a notice on the door saying, "We're coming back and we're going to throw you out." So the first time the sheriff goes to the property, they don't actually throw the tenants out. They just post a notice on the door. But if you have not left already, this is your time to leave, because they will come back next time with guns drawn if necessary, and you'll be physically evicted from the property if that happens. On the actual moving day, the sheriff minds the people and the landlord manages the property. What that means is the sheriff comes and they pretty much just stand around and tell jokes. But if anybody gets in the way, like an occupant of the property, then they calm them down and they have them leave the property, and the landlord has a moving crew to move all that stuff out. And they're going to have a locksmith with them too, so the locks are changed. If you get to that far, you are literally going to be homeless. So you sure don't want to be that way. You don't want to be out on the street. You want to plan for this stuff well ahead of time. And whether you fight an eviction or not, an eviction is going to really hurt you. We all know that the rental market is incredibly tight and has been for several years. It is rare that you see a for rent sign anywhere around town now. And if the place is somewhat decent, it's going to be grabbed up real fast. That's just how tight the rental market is. And if you have an eviction on your record and you're competing for an apartment with somebody who doesn't have an eviction on your record, guess who's going to wind up getting the apartment? The one who doesn't have the eviction on their record. And it's not only that, but potential landlords and employers can see on a background check whether you've been evicted before. So that can even include just a judgment for an eviction. Even if you're not physically evicted and you have a judgment against you for the eviction, that still could show up on your record when somebody does a background check on you. Last year, the legislature implemented a new law for what's called suppressions. Some judgments for possession will now be suppressed, but that's only if both parties agree to have them suppressed. That means that they're not going to be visible on public records. But if the landlord doesn't like you, and you've given the landlord trouble, then the landlord is not going to consent to a further suppression of the records, which means they'll be open for anybody who wants to check your background. It's really a horrible situation to be in. And afterwards, if the landlord has a judgment against you for damages, you could face garnishment. You have the embarrassment of having a garnishment served on your employer at work when they knew nothing about this ahead of time. Your employer comes to you and says, "What's going on with this?" And that could jeopardize your job. So future landlords are going to check with your current landlord to see what kind of tenant you were. Most reputable landlords will do that. If the prior landlord had to evict you, what kind of review do you think you're going to get in front of that new landlord? It won't be good. Okay, and as I mentioned before, we have a very tight rental market. So this is something you don't want to mess with. Okay, now here's something that everybody ought to know, both landlords and tenants. This is a very strict portion of the law. Okay, so suppose you're now out of your place, whether you were a good tenant or bad. Within 30 days of the time that you leave, the landlord has to account for any security deposit that you paid. They have to account for it by sending a letter to the last known address that you have. If you don't give a new address to your landlord at the time you leave, they're going to send it to whatever place you were living at, even though they know you're no longer there. And the landlord has to account for whatever security deposit was paid. So for instance, suppose you paid $1,000 in security deposit, okay, but you owed $1,000 in rent. So here you have a line item that says, here's your $1,000 in security deposit. We took away $1,000 for rent. We took away $500 for cleaning the apartment. We took away $300 for repairs. We took away $200 for something else. And all of a sudden you have a deficit beyond what you paid in your security deposit. The landlord may come after you for that deficit, but the bottom line is they have to send an accounting, whether you were a good tenant or a bad tenant. And if they don't send that accounting, then within the right period of time, then you can get your entire security deposit back. So the time limits that are imposed, the basic time limit is 30 days after you have left a property. However, the lease can give the landlord up to 60 days to send a security deposit letter. So if the lease gives the landlord 30 days, then that's all the time they get. If the lease gives them 45 days, that's all the time they get. If the landlord wants to get 90 days, they can't get that. The maximum they can get is 60 to send a security deposit letter back to you. And whatever monies that they determine that they owe you, they have to include with that letter. Okay, if the landlord forgets to do this, then you or your attorney sends them a nastygram saying you owe us this money. And if they still refuse to send that money, then there's a chance you can get 3 times the amount of your security deposit plus attorney fees and court costs if the landlords don't give it back to you. So it's a pretty serious thing. And many times landlords don't know about this, or they forget to do that, because it has to be 60 days after the time that they knew or should have known that you were leaving the place. And it's best if you give them notice. This is where I moved to, this is where my new address is, and then they have to send your security deposit letter and any security deposit you're entitled to get back to you. They have to send it to that new address. So that is pretty much all I got. If you want to see a summary of this presentation, you can go to my website, or you can email me, and I'd be happy to email you a copy of this presentation in PDF format. And that's all I got.